Hello, my name is Lori Siegel, and today I'm going to talk about a case where a lawsuit was filed due to a car collision with a drunk driver after a football game in 1999. This is a fairly long case with many defendants, so I'll do my best to summarize the case without taking too much of your time. So I'm going to start with some background information. On October 24th, 1999, the plaintiffs Antonia Verni and Fazila Basque were seriously injured when a car driven by one of the defendants, Daniel Lanzaro, collided with their vehicle. Fazila's daughter, Antonia, was 2 years old at the time of the accident. Lanzaro had spent the afternoon at an NFL game held at Giants Stadium in East Rutherford, New Jersey, and at two bars after he left the stadium. He was visibly intoxicated at the time of the collision, according to police on the scene. In addition to suing the driver, the plaintiff sued the holder of the stadium's liquor license, Harry M. Stevens, which I'll refer to as HSM in the rest of the paper, under the state's dram shop law. The relevant portion of the statute spotlights a licensed alcoholic beverage server to liability only where the server carelessly serves alcohol to a visibly intoxicated individual. Similarly, the plaintiff sued that HSM and Aramark Inc., which I'll refer to as ASM, violated their alcohol service policy on the date of the accident and on many other occasions. Furthermore, on December 14, 2000, the plaintiffs filed a complaint seeking compensatory and punitive damages against Lanzaro, Ronald Verni, the New Jersey Sports and Exposition Authority, Giants Stadium, the New York Giants, Harry M. Stevens, and Aramark, two bars frequented by Lanzaro after the game, Shakers and the Gallery, and Michael Holder, the passenger in Lanzaro's car at the time of the accident. So let me just present some facts that occurred. On October 24th, during the NFL game at Giant Stadium, Lanzaro consumed at least three 12-ounce beers during his tailgate prior to walking into the stadium. He purchased two 16-ounce beers by the first quarter and admitted in court he was drunk. At halftime, Lanzaro purchased four 16-ounce beers from an employee at a portable beer cart once the game started. The stadium had a two-beer limit, but Lanzaro claimed to get by this rule by tipping the server extra money. After leaving the football game with his friend Michael by the third quarter, the two friends proceeded to consume more alcohol at the two local bars, Shakers and the Gallery. While driving at around 5:45 p.m., Lanzaro collided into a 1999 Toyota Corolla driven by Ronald Verni. Antonia was found unconscious in the back seat with her mother stuck behind the driver's seat. Sergeants George Neteklos and George Shihanian of the Hasbrook Heights Police Department, who arrived shortly after the accident, observed that Lanzaro was intoxicated. Nearly 45 minutes after the accident, Lanzaro was found to have a blood alcohol concentration of 0.266% and was arrested. He would be later sentenced to a 5-year term. Furthermore, on November 18, 2004, the court approved an approximately $1 million settlement on the following: a $190,000 settlement between Antonia, ELRAC, and Toyota, and a $701,000 settlement between Antonia, Sports Authority, the NFL, and Commissioner Tagliabue. Furthermore, during the trial, ASM argued that it was a representative of HMS, and therefore any analysis of its alleged negligence should be governed by and limited to New Jersey's dram shop statute. The trial court accepted this argument but did not rule on the issue until the third day of the trial, when tainted evidence was presented by plaintiff's witnesses and by Lanzaro himself. As a result, ASM argued that the evidence went beyond the scope of the Dram Shop Act and was in fact prohibited evidence that was unfairly detrimental. This argument would be heard and agreed by the appellate court soon after. The Superior Court Law Division of Bergen County entered judgment on the jury's verdict, finding the motorist and concessions contractor and lessor of beer servers liable. The daughter was awarded over $53 million in compensatory damages and $65 million in punitive damages. The mother received $6.5 million in compensatory damages and $10 million in punitive damages. Due to multiple errors in the course of the trial, a new trial was demanded, which would take place May 30th, 2006, and would be later decided on August 3rd, 2006. So, going to the legal decision, the legal problem recognized by the appellate court is that it's impossible in retrospect to decide what part of the testimony the jury relied upon to make its decision, as it was found Lazzaro's evidence was improperly admitted. Here is the case decision. The appellate court concluded that the culture of intoxication evidence should not have been admitted prior to determination of the beer vendor's agency. The appellate court stated, by failing to resolve the issue of the vendor's role prior to the commencement of trial, the trial judge allowed a plethora of references to the drinking environment, a culture of intoxication at the stadium that was not relevant to the limited issue of service to a visibly intoxicated person. The error was compounded by the absence of a jury instruction that all of the evidence admitted during plaintiff's case in support of their common law negligence claim against the vendor should be disregarded. So, the New Jersey Appellate Division ruled in overturning of the more than $100 million jury award and a retrial. Some of the retrials was based on the following holdings. Evidence of rowdy behavior over the years by people attending professional football games at a stadium were not relevant. Evidence that over the years attendees of a professional football game at a stadium were drunk was not relevant. And evidence that 2-year-old passenger's father, Robert Verney, had unsafely secured the passenger in an adult seatbelt was inadmissible for purposes of allocating fault. So I hope you guys enjoyed this case today, and I hope you have a great day.